The Arizona Center for Disability Law presents Dispute Resolution Options: Considerations when signing settlement agreements. Unfortunately, parents who sign settlement agreements often realize later that they will not be getting what they bargained for. Before signing any written agreement related to your child's special education rights, it is important to fully understand what is in the agreement and how it will impact both you and your child. When writing or reviewing a settlement agreement, it's important to ask yourself the following questions. 1. Is every agreed-upon provision in the written agreement? There should be at least one paragraph describing each of the terms that you and the school discussed. 2. Are the details about each provision in the agreement? The details count. For example, if you agree to a staff training, does the written agreement cover which staff will be trained, by what date the training will be completed, who will be providing the training, if, when, and how the school will provide evidence to you that the training has been completed, and what topics and information will be taught during the training. Leaving out important details may leave you dissatisfied with the agreement results. 3. Does the agreement use language that creates an obligation? Language that expresses an intention or a wish does not create a legal obligation. For example, language such as, the school district will make efforts to, the school district may, or the school district will try to, express intention only. Instead, make sure to use language such as the school district will, or the school district shall when describing the areas of the agreement. 4. Do any of the words used to describe the agreement need to be defined? Many terms that are used in a special education settlement agreement, such as independent educational evaluation, are already defined by the IDEA. If a term is unclear and can be interpreted more than one way, there is a chance that you and the school will have different interpretations. To avoid future disputes about the agreement should define key terms. 5. Is there anything in the agreement that you don't understand or didn't agree to? If you don't understand something added by the school, ask questions. Schools often include what they consider standard provisions in settlement agreements, and some of those provisions may indeed be standard, but other provisions may affect your child's future rights and choices, and you need to be very cautious about such terms. Examples of these kinds of provisions include requiring you to disenroll or never re-enroll your child in the school district, ending services before your child graduates with a regular diploma based on state standards, severely limiting your ability to communicate with the school district, or limiting your ability to exercise your IDEA procedural rights. If possible, retain an attorney to help you through the negotiation settlement process. Having an attorney explain the terms of the settlement agreement you are being asked to sign will help you to make an informed decision about whether or not to settle. For more information and guidance on settlement agreements, visit azdisabilitylaw.org or call the Arizona Center for Disability Law at 800-922-1447. Funding for this video provided by the Arizona Developmental Disabilities Planning Council.